House Bill 542, which was recently passed in the North Carolina legislature, essentially allows a defendant, the at-fault driver, to take a credit for the plaintiff's either health insurance, Medicaid, or Medicare. The way it will work is very simple. If you have a bill, for example, at the hospital that's $50,000, and you also have Blue Cross Blue Shield that pays a portion of that bill, and then they take a write-off. An example would be that they take that bill and they pay $15,000 and write off a portion of it. Now the insurance company gets to take a credit for the amount that's been paid down, and instead of using the original bill, the $50,000, to make your claim, we now will have to use the reduced amount to make a claim on behalf of an injured individual. It should come as no surprise that the individuals and/or corporations that are responsible for House Bill 542 are the insurance companies. The only individuals and/or corporations that stand to gain under House Bill 542 are insurance companies, because now, theoretically, they're going to be able to pay less out per claim if an individual either has health insurance, Medicaid, or Medicare, since they'll now be able to take a credit. It does not create any jobs. It does not create any windfall for anyone, including the defendant, other than the insurance company that insures them. In North Carolina, if you have health insurance, Medicaid or Medicare, the impact could be significant in that the value of your claim, or what your claim used to be pre-October 1st, 2011, now will be diminished and devalued, because the insurance company will now be able to take the benefit of your health insurance as a credit against what actually is able to be produced and introduced into evidence as your actual bills. Now, going forward, if you go to court, which translates back to any cases that are at pre-litigation, you will no longer be able to present the actual bill, but only the amount that actually needs to be paid to actually satisfy the bill. So using an example I'd used in the past, if you have a $50,000 bill, Blue Cross Blue Shield pays $20,000 of it. They take a write-off of $20,000, and you owe $10,000 as co-pays or leftover client responsibility. Instead of submitting a $50,000 bill towards the value and the valuation of your personal injury claim, you would now only be able to present $30,000. It should come as no surprise that many cases are valued not only by the injuries, the severity of the injury, length of treatment, type of treatment, if there's any kind of permanency or disability, but also the amount of the ultimate bill. If the bill is reduced, it goes without saying that the actual value of the case has thereby been reduced, minimizing the exposure to both the defendant and the insurance company. So using that same scenario, and it works the same for Medicaid, Medicare, just to a more drastic example. A drunk driver plows you down with your family in tow. Your health insurance pays a significant amount of the medical bills. The drunk driver who was at fault for causing your injuries now gets to use your health insurance as a credit to help reduce their exposure to you on the claim. It's just unfair.